are. There we go. Fantastic. So yes, I'm going to be talking about what are the intellectual property considerations when doing international trade. I'm going to just cover a couple of things regarding IP and the specific kind of types of IP we come across in business. Not many people know the differences between a copyright, a design, a trademark, a patent, or possibly even know-how. And it's important for you as business owners and possibly people expanding into new markets to know what are your core IP and your assets of which you want to protect. So intellectual property is the creation of the human mind, the human mind being missing there. A lot of talk is going on about AI and ChatGPT and what this means for intellectual property. Currently, it is only limited to creations of the human mind. And if you want to discuss this further, you can take my email down at the end of the presentation, and we can maybe debate whether I'm right or wrong. Most legal minds tend to agree that AI-generated IP is not necessarily IP in the true sense. So just a very brief definition of what IP is. Intellectual property encompasses the products of human ingenuity and creative endeavor. I'm not going to read the full slide, but it's important that you who are dealing in this space nurture and protect and also enforce the intellectual property that you own against others from infringing upon it. Think about brands like Nike. What would they be without the swoosh? What would Apple be without the Apple? What would Microsoft be without their proprietary rights to their software? There would be shells of companies. So when you look at a product, you've got to think about what IP rights do I have to that particular product, or maybe even that service to which I'm rendering, because you don't want people to copy what you're doing. There's value in what you're doing, and it's worthwhile protecting. So you have a great idea. What now? You may have a new idea for a line of affordable activewear because Gymshark and all these other brands have just become too expensive. Maybe you're stuck in traffic and you've created some sort of invention to solve our traffic light woes in South Africa. For any of you who are sitting here today and you create that invention, I will gladly file that patent for you for free. So here are just some of the forms of different IP. I won't go into the main four, which most of you have heard of, because I'll deal with that a little bit later on. Those big four being trademarks, copyright, patents, and design. But some of the lesser known forms of IP are technical know-how. This is the knowledge of methods or techniques of doing something. An example would be how to replace the screen in your brand new Tesla, if we get them here, ever. We also have things like geographical indicators. Who of you have said to your girlfriends, I want a glass of champagne and it's a sparkling wine? I am afraid to correct you, but you cannot say that. You need to be specific about your geographical indicators. We in South Africa have a phenomenal brand, Rooibos tea. Rooibos tea, Rooibos being a geographical indicator. Karoo lamb is another one. And I know with the AFC-FTA, they are looking at geographical indicators in the IP protocol, which Trudy mentioned just now. With digital trade, another important thing to consider is your domain name. Do you remember the .com race? And it was an important race indeed. We don't want our names being misused on the internet. Nike does not want Mikey to be selling their shoes. We've spoken a lot about agriculture. One of the other things that needs to be protected are plant breeders' rights. People are creating new variations of plants every single day. And we're looking at possibly the cannabis industry as well. I know that hasn't been discussed, but it is something that is on a lot of people's minds. I'm looking at a lot of people nodding in the audience. Performance rights. We've spoken about musos and artists. I didn't catch your name, but the lady who designed these dresses, they are stunning. You deserve protection. This is an artwork in itself. Congratulations, you're doing. Had I known, I would have commissioned my own suit. next time. Other things like trade secrets, these are own formulas. Can anyone think of a trade secret of a particular beverage company that is protected probably better than Fort Knox? The recipe to Coca-Cola. Some of you you are all on top of this. I'm not sure if the rumors are true, but apparently there's 2 people in the whole world who know the recipe. They're not allowed to know who each other are, and they have to travel in separate planes, and but yes, trade secrets are a very crucial part of your IP protection. So you have a new business. What should you do to protect your IP? The first step is to identify what type of IP are we working with. Is it a copyright work? Is it a trademark that I'm looking to protect? Maybe, like I said, you've created this invention to solve our traffic light woes. Then you need to identify what is your core IP. Another thing that comes up a lot, especially once you've already registered and now are trying to enforce, is ensuring that you document and keep records of the entire creation process. For those who are designing dresses, your sketches, keep a record of that. For those who are in the digital space, whatever source code drafts that you have, keep that a record of, because people will try and copy it, and if you can show them that, sorry, listen, I was first, here's the record, you'll be in a much safer space come enforcement time. Protecting confidential information, like the recipe to Coke, and some of your ideas. Be careful who you speak to on a plane. Patents and ideas have been lost to casual conversations on a plane. Reduce your ideas to material form and keep them secret and keep them safe. I think that comes from Harry Potter, I'm not too sure. Anyway, use non-disclosure agreements, confidentiality clauses, and other sensitive information must be kept safe at all times. Securing confidential communications, encrypt your data, encrypt your documents. If you're sending some sort of design or idea to a third party, make sure it's encrypted and that party signs an NDA, or at least a non-confidentiality clause to your agreement. Use strong passwords, 2-factor authentication. Seek legal advice. Listen, you don't have to come to me, but there's plenty of lawyers out there that will be gladly willing to assist you on this issue, but I would prefer the work. Take action against infringement. Do not allow people to infringe your IP. We have seen plenty of companies lose reputation, goodwill, and the ability to claim protection because they failed to take action. It is expensive, but it will benefit you in the long run. So let's start with a trademark. I know we are very short for time, but I'm going to keep this quite brief. Trademarks are anything from a brand name, a slogan, or a logo. There can be a word mark or a device. Some of the South African famous trademarks are the likes of Nando's, and some very famous international slogans are Nike's Just Do It, McDonald's I'm Loving It. You can register your trademark. In most countries, in all countries, trademarks are territorial. There are some regional systems in place in Africa, which I'll get to just now, which are WAPI and ARIPO, that deal with regional filings of trademarks. But what you really want to look at when you're developing a trademark is this distinctive? I saw something very funny on LinkedIn yesterday. I don't know if any of you are attending the Backstreet Boys concert in the next month or so, but I think Nick Carter says, am I the only one? And that's what you want? And is there any other? Those are the two things that you need to consider when looking at your trademark. And that's what I mean by distinctive. Can you distinguish or separate your brand from someone else? Also, a lot of people, when they start in this space or start a business, they want people to know what they're selling. So they make their trademarks quite descriptive of what they're selling. It will be Scott's sneakers, for example. Can I separate sneakers and Scott's from anyone else's product? Do I have a monopoly over the word sneaker? No, you won't. And a great example of sneaker stories is Drip. I'm sure you've all been driving along the highways and that the drip shoes are everywhere. That's a great name for a trademark. So I'm doing this interchangeably between the two. So the benefits of registration: security, you get rights to license and assign. There is money to be made with IP. It is an asset, treat it as such. Register it, there are common law rights to your trademarks, but it will secure your protection if you register it in the countries in which you are operating. I have spoken a little bit about a repo and a IP, but please bear in mind that trademarks are territorial internationally. There are some other organizations like WIPO, and which is the European International Office, so you can get protection in regions outside of South Africa for a variety of trademarks. The next thing is copyright. Some examples of copyright are literary works, books, instruction manuals, recipes, musical and artistic works. These are paintings, sculptures, song compositions. Another one of important note is computer programs. This is a hot topic at the moment, especially with the digital trade space. People are developing apps left, right, and center for whatever they're doing. And with copyright, you have automatic protection as long as your idea is reduced to a material form. Writing a book, if you have the idea for the next Harry Potter, write it down. These are just some of the requirements. What I did want to mention on this particular slide is the Berne Convention. We're talking a lot of legalese and treaties and conventions, but just simply the Berne Convention protects authors of literary works and artistic works from having their, let me give you an example. If you create a book here in South Africa and you will have copyright protection in another Berne Convention country as long as that work was original, and yeah, that's pretty much. It needs to be original and needs to be in a Berne Convention country. I think, over to patents. Patents are, I'm going to keep it simple, are inventions. There are some requirements. These are fairly common requirements like trademarks. Patents are also territorial. Designs, we have two forms of designs in South Africa. They are aesthetic and functional designs. Again, territorial. These form part of the AFCFTA agreement and have been put into the IP protocol and are of particular interest for many, many IP practitioners. The lady who designed the dress, your patterns on your dress could potentially be protected by design rights, and you could be barring other people from using those patterns on dresses and potentially jewelry. So be smart, do your homework. I think, oh, there we go. Be smart, do your homework. If you are unsure of who or what your IP is, discuss internally with your legal teams, your market teams. What are you working on? Do we have existing contracts? Are there any joint ventures? Are we working on a new advertising campaign? Are we launching a new product? How should we protect this product? What a percentage of our business depends on our IP? I think if any of you have watched the Shark Tank, and the guys, when they are asking those bright-eyed and bushy-tailed entrepreneurs, do you have a patent? Do you have a trademark? There is a reason for those questions, because they know that they can monetize that IP. And if you don't have the IP, you don't necessarily have a commercially viable company. So some of the commercial considerations with IP, obviously you can make money. There's royalties, licensing, franchises, coexistence agreements, distribution rights, manufacturing, and joint ventures, which you can all benefit from if you have IP in place. These rewards increase value, financial gain, you will garnish goodwill, there will also be tax relief benefits in certain cases, and you will have the monopoly to use that particular IP. So moving on to Africa, which has been the topic of today. doing intercontinental trade. We have touched on the AFCFTA agreement and the various protocols. Trudy mentioned it a little bit. So now that we IP 101 is over, your certificates will be sent in the post, and it won't be registered post. We're going to discuss some of the common barriers to intercontinental trade in Africa. The first being different IP laws and regulations. As I said in my previous slides, IP for the most part is territorial. Different countries have different laws and regulations. The IP protocol, as well as some of the other regional organizations, try to dispense of these barriers by creating regional organizations which will assist companies in having a greater reach with their IP protection. Unfortunately, some countries have not kept up to standards with certain IP protection legislation. There are some particular extraneous circumstances for that, where there is weak or non-existent IP. Most countries in Africa do have specific IP legislation and can be enforced, but it is one of the barriers to entry, and it's something you should research or take legal advice if you intend to go into a specific territory. What are the IP rights in that country? Infringement, this goes hand in hand with weak enforcement. If there is a weak regime in terms of IP enforcement, there will obviously be infringers. We're seeing this also in counterfeits, people copying products. So bear in mind, do the research, find out what the type of IP enforcement is like in that particular country. The time and costs. IP enforcement can be expensive, especially in certain countries. So bear that in mind when you are deciding on which country you are going to be operating in. There's also technical barriers to trade. We haven't really touched on this. This unfortunately falls within Lorato's realm with TBTs. I know the DTIC are looking at putting in place the WTO's TBT agreement and the regulatory framework for product requirements, so that when we have a specific spec for a product, it's not necessarily stopped at the borders and said, sorry, you don't meet our technical requirements. Also, different countries value IP differently. There's a lot of formulas and considerations that are going into IP valuations, which I won't necessarily discuss today. And tax. You know, tax is a huge thing. This is exactly what the AFCFTA seeks to eliminate, is the tax considerations when doing trade internationally. And that's what we're hoping for here. I briefly spoke about a repo and OIP. I know we're limited to time, so I'm not going to go into too much detail, but both organizations deal with either Francophone or Anglophone countries and intended to assist those countries with having their trademarks, designs, and patents registered through one centralized office. So if you are looking to file a patent or a design or a trademark in any of those highlighted countries, it's worthwhile filing through either OIP and a repo. So moving on to now what Trudy mentioned briefly, which is the protocol on intellectual property rights. Recently, I think it was the 18th and 19th of Feb, which she said, where phase 2 of this particular protocol was presented at the AU summit in Addis Ababa, where heads of states deliberated of its adoption. I also have not received any further feedback on this particular adoption, but the IP protocol seeks to harmonize rules and principles in the promotion, protection, cooperation, and enforcement of intellectual property rights. It looks at everything from traditional knowledge to design to copyright to trademarks and all of the other forms of IP that I've mentioned. I'm sure these slides will be shared after the presentation, but this is just some of the specific objectives of the protocol. There were and are still some intellectual property concerns with the protocol, some of which have been addressed and some which have not. Firstly is the enforcement of IP. We have spoken that most countries, well, not most, some countries in Africa have difficulties with their IP protection and their enforcement. The protocol has stipulated that member states must integrate or at least adopt their own IP regulations and legislation regarding those particular forms of IP. So we will see how that kind of develops over time. One of the core issues that has been discussed over the last years, especially with COVID, was the access to medicines. With patents, certain restrictions may apply to countries getting access to healthcare because of patent laws being in place in other areas or other countries. Article 12, I hate being a lawyer and citing articles and sections and all of that, but Article 12.3 makes provision that state parties must allow that the laws on patents in their countries do not hinder access to medicines, vaccines, diagnostics, therapeutics, and other healthcare essential tools consistent with intellectual property treaties to which they are a party to. Moreover, each state must, within 3 years from coming into force of the IP protocol, ratify the 2005 protocol amended by the WTO Agreement on Trade-Related Aspects of Intellectual Property Rights in relation to public health care and provide procedures that enable the export of pharmaceutical products produced under the compulsory license for the benefit of state parties that have limited or no domestic pharmaceutical manufacturing facilities. In short, allow other countries to get access to medicines by, maybe not disregarding patent rights, but certainly waiving certain patent rights. Another key topic was traditional knowledge. We in South Africa have a lot to consider about traditional knowledge. If any of you watched the Black Panther movie, you would have seen the influences that traditional garbs have on even movies. And there was a lot of debate and talk about whether the producers for Black Panther sought the necessary consent from the relevant tribes when they were developing the costumes in that film. Traditional knowledge is used in a variety of different types of products and is considered in the IP protocol and requires that those who are creating new forms of IP that is based on traditional knowledge are at least acknowledged, compensated, and receive consent or asked for consent. I'm probably going to have to speed things up, but a couple of other things: technology transfer, counterfeiting. But one of the main thing I want to wrap up is on the key considerations when doing international trade from an IP perspective. Understand the laws in the country in which you're trading. Familiarize yourself, seek legal advice. Can I register a trademark? Will I have trademark protection? Are there already trademarks that are similar to mine in that country? Protect it, register, look at the availability in each market that you're trading. Respect the intellectual property rights of others. Do not seek to infringe others because you will be subject to possible infringement proceedings. Consider licensing and joint venture agreements. This allows you to easily transition into new territories. It will also bolster your bottom line by getting royalties and other forms of compensation for that IP. Continue to monitor and enforce your rights. Take legal action. So just a simple takeaway: know your core IP, take measures to protect it, and that is my time. I'm sorry that I had to rush a little bit, but yes, I hope you learned something today.